Even if they weren't, they were documents which were sent to him on the 20th of May, so 6 days after the letter, and they're the documents that he had and had considered before he made any investment or purchase any shares. So if we look at page 196 first, Your Honours, we see the heading in capital letters, Exotic Key Mortgage Corporation Limited, proposed Key Bank International Limited. And if I can ask you to turn over the page, or I think Ms. Pitts will swipe it, I think is the modern word. You will see on the next page, 197, Exotic Key Mortgage Corporation Limited, confidential and private memorandum. This memorandum is distributed as an informative tool to potential investors in Exotic Key Mortgage Corporation Limited, the Bahamas, currently converting to Key Bank International Limited, a Belize licensed Class A international bank. And plainly, that is referring to something which is in the process of being done, not something which has already been done. And that is spelled out in black and white on the next page, 134. You'll see under the heading Overview in the second paragraph, in 2003, ECI, that's Exotic Key International, intends to spin off ECMC, which is Exotic Key Mortgage Corporation Limited, as an independent company, which in turn shall become Key Bank International Limited, a Belize Class A international bank.
If I understand it well, that conversion did not take place?
Well, the establishment of the bank took place, and the conversion, if it's considered as a literal matter, it did not take place exactly as represented. On the other hand, can I remind Your Honours that the respect in which this representation was alleged to be false was because the bank had not yet been incorporated. And there was no complaint pleaded as to the precise mechanics of it. The complaint was he was told the bank was already in existence when it wasn't. But that cannot be maintained in the face of the document I've just shown you, which he received. And then in the subscription agreement, which you will find at page 204, you will see on the first page, again, Exotic Key Mortgage Corporation Limited, proposed Key Bank International Limited. And on the next page, the fact that the agreement between the respondent was being asked to make was between Exotic Key International and him and Mr. Haugen. It is wholly unreasonable in those circumstances to suggest that he did not realize the true position in relation to Key International Bank Limited. And if this is exactly what you would expect to happen in a transaction of this sort, an initial letter seeking interest, and then the documents being sent, which the investor will read and make his decision on the basis of. And indeed, that is spelt out in entirely usual terms on page 209, where you will see the subscriber, Mr. Haugen, agreeing at H that he has received from the issuer a copy of the memorandum and any and all other information that he deems necessary or appropriate to enable him to make an informed decision concerning his investment in the units, which again is something that you would expect to see and something which is to be found in all such transactions. Now, I come to what I submit is an extremely significant matter. Neither the memorandum, which I've just shown you, nor the subscription agreement, which I've just shown you, is mentioned by the judge at first instance in his judgment at all. And if your honours go to page 166, you will see he sets out a detailed chronology of events where he refers to the letter, and he then says, based on the letter, Mr. Haugen agreed to invest. Nowhere in the chronology do these documents appear, and in our submission, they're simply omitted from the narrative altogether. But of course, they are of vital importance, both to the issue of whether the original letter was misleading and to the issue as to whether the respondent can have relied on it. And for the judge simply to ignore them, in our submission, throws really a spanner into the judgment altogether. And these documents are mentioned by the Court of Appeal, but if I can take you to the reference where that takes place, it is at page 105. In paragraph 20, where as part of the narrative, Mr. Justice Awich says, in May 2003, Mr. Haugen informed Mr. Nagel that he was interested in investing in Caye International Bank. Mr. Nagel sent the proposed subscription agreement of Caye International Bank to Mr. Haugen. A memorandum and articles of association was not included. Now, that is the only reference, I think, to those documents in the Court of Appeal judgment. But it's quite clear from them that they did not either appreciate the significance of the memorandum and subscription agreement in the issues, whether the misrepresentation was false and whether it was misleading and whether it was relied on. It also seems that there may have been a mistake insofar as they say a memorandum and articles association was not included. Of course, a memorandum was. The only memorandum was sent and was referred to in evidence. And of course, there would have been no memorandum and articles of association of the bank because it was not yet incorporated. So it appears that just as the judge, the Court of Appeal did not appreciate the significance of the fact that Mr. Haugen had invested on the basis of the memorandum that he had been sent and the subscription agreement which he had also been sent and which he had agreed to. So we say that given, first of all, the receipt of the memorandum and articles of association and the subscription agreement, it is really impossible to maintain that the respondent is entitled to succeed on the basis of the original letter inviting his interest, which was superseded by what took place thereafter. That goes to the root of the claimant, now the respondent's case.
The trial judge, Mr. Guthrie, was referring at paragraphs 20 and 21 of his judgment. He said Mr. Haugen was provided with a proposal and subscription agreement. Is that a different matter altogether? Or
I'm sorry, Your Honour gave me a reference at paragraphs 20.
20 and 21 of the trial judge's judgment.
No, Your Honour is quite right. I may have overestimated my position, but the representations that he then refers to have absolutely nothing to do with the memorandum and subscription agreement. They're all the letter. And indeed, that's the way the matter was pleaded. He doesn't, the proposal and subscription agreement at paragraph 21 did not contain A to F. Those are the representations which he says were to be got from the letter. So that is, in fact, an error on the part of the judge. The reason I say that he made no reference to the memorandum and subscription agreement is because he did not include it in any way in his reasoning that the letter contained the representations which he said were false.
So in effect, both courts dealt with those documents in the same way. Did not analyze their legal import.
And in effect, they were both wrong, with the greatest respect, Your Honour, because it must be uncontroversial that if an original letter inviting investor interest is then superseded by the information on the basis of which the investor makes his decision, that he can no longer say, well, I relied on certain matters in the letter. But we say those matters were not false in the first place. But on the reliance issue, it is, in our respectful submission, impossible for him to say now, well, I relied on the fact that the bank had not been incorporated. I relied on the fact that it had been incorporated when I knew perfectly well that it hadn't. And we can see, and this is in fairness to Mr. Haugen, that when he came to give evidence, he was cross-examined by Mr. Williams, who was my predecessor in the case at that stage. He was cross-examined by Mr. Williams, and he accepted that he had received these documents, and indeed that he understood the position. And it's important, I think, that I take you to that passage of his, of the transcript, which you have in the record. It begins at page 470. Sorry, no, it begins at page 470. And to put this in its place, this is a passage in the evidence where Mr. Haugen is in the witness box and he is being asked questions by Mr. Rodwell Williams, a senior counsel. And perhaps it's best to start simply by confirming that he had accepted already that he had received the memorandum and the subscription agreement. And he's asked on page 470 a number of questions. If I begin at line 15 or just above line 15, you'll see that Mr. Williams says to him, now let me take you to the prospectus. And that prospectus is the memorandum, which I've shown you already. And he refers him to the place in the bundle of documents at that stage, and he says, thank you. The question at the bottom of the page, the prospectus that you received, Mr. Haugen, that's the one you receive, right? And he says, yes, it is. you agree with me that this is a prospectus by Exotic Key Mortgage Corporation Limited, which is headed at the top, Exotic Key Mortgage Corporation Limited. Yes, that is correct. And if you look at page 118, it says Proposed Key Bank International Limited. You see that. That's what it says on the front, right. It says proposed, right. Yes, it does. That word there, I suggest to you that it means that its Key Bank International is not in existence. It's proposed, right. It says proposed. I suggest to you that means to you it's not in existence, it's proposed. That's probably what it means when this document was made up for Exotic Key Mortgage Key Bank International, yes. That is the document that was given to you, you said, yes. And I'm asking you, what is your understanding of proposed, where it appears there in brackets, then Key Bank International, exactly what it says, proposed. So that means it doesn't exist, right. That means that it may be in the process of Exotic Key Mortgage Corporation being converted into Key Bank, as they said, Mr. Nagel said in other statements. And then repeats that. A Key Bank, it was stated to me, the mortgage company was going to be converted into Key Bank International, and maybe the conversion had not yet taken place. There's some toing and froing about the word proposed, conversion. He said, go to 119, this memorandum is distributed as an informative tool, etc. What do you understand that to be saying? This pays in this document, as it says, currently converting to Key Bank International, a Belize-issued class international bank. It says a Belize issue or a Belize class licensee. You accept that this bank was not in existence, and he answers a number of questions. And he says at line 12, I treated this as a process that is happening here, the conversion of the mortgage company to Key Bank. And on page 474, he's asked about what I read to you. ECI intends to spin off ECMA as an independent company, which in turn shall become Key Bank International Limited. And he says, is that consistent with your understanding? And he says, yes, it is.
I think we have the point.
Yes, I think you have the point, Your Honours, and I don't want to waste any more time on it. The point is that that should have been the end of any case of fraudulent misrepresentation. The facts had been set out, and the respondent accepted the position, and it flatly contradicted any reliance, which is the misrepresentation pleaded that the bank had already been incorporated. The next point on that depends on the passage of the letter. Again, the same passages as I read to you before. One does need to look very briefly, I think, at the way in which the bank, the judge treated the issues. With the greatest respect to him, he appears to have leapt to a conclusion that the case against the appellants was proved. If one sees what he says to Mr. Williams in a transcript, which I don't propose to take you through in any detail, but it doesn't make, in our respectful submission, very comfortable reading. You'll see at page 517 of the transcript that Mr. Williams begins his closing submissions he is about to get going, if I can put it like that. On page 520, he says, I indicated to my learned friend that I will just close, and that's at about line 9. The court immediately says, let's cut to the chase. I will go straight to the point you are raising. Let's go straight to the point. Look at the letter. This is written by Joel Nagel, right, before the company were incorporated, before the company was incorporated. And then the judge quotes from it at the bottom of the page, "Our application for a Class A license was finally approved last month by the Belize Central Bank." Was that true? Well, as Mr. Williams says, it was in fact true, and there was an application that had been approved. And the judge takes him to task about that, to the extent that at the bottom of that page, where Mr. Williams says, "I am saying that it is substantially true, yes," then, Mr. Williams, something is wrong with your morality. And if I can summarize what happens thereafter, the judge, and I don't think it's really fair to my client if I mince words too much, he goes for Mr. Williams. Everything Mr. Williams says is challenged, sometimes in highly personal terms. The judge, with respect, was wrong to do that. And it was unfair to the appellants for him to do that. And as I say, I think it would be, so to speak, unnecessarily gilding the lily if I were to go to all the points in the transcript where the judge does that. But I do invite Your Honours, if necessary, to remember the references at 519, 523, 524, and 526.
I think you'll have to repeat those, please.
Oh, I'm so sorry. 519, 523, 524, and 526. But I'm mindful of the time allotted, and I don't want to say the same thing too many times.
And the pages are in your speaking notes. So.
Yes. Yes, indeed. My speaking note includes the references. But if I can just go, please, to an important matter at page 529.
Okay.
The court, again, so to speak, taking the lead at the bottom of the page, says, let's look at the facts. One of the conditions that was imposed was that they had to raise $3 million. Look at condition 4. Initial paid-up capital should be $3 million and shall be lodged in a financial institution acceptable to the bank. Now, the judge appears to have thought that as about the most damning thing against the appellants that there was. And the relevant passage, again, for your lordships, or your honours notes, it goes to page 534. But if you go back to the letter, which the judge was basing his decision on, it's exactly the opposite. Because in the letter, Mr. Nagel is saying, we are required, before we can open, to raise $3 million cash capital. That's the third paragraph on page 104. This requirement has created an incredible opportunity for just a few sophisticated investors. So it cannot possibly be maintained that there was anything misleading about that. It was being spelled out in black and white. The judge, however, set great store by this, and he said in his judgment, and this is at page 173, by your honours,
What paragraph you at, Mr.?
page, in my speaking note.
No,
in
judges,
that-
I have slightly different page numbers
Oh, I'm sorry.
myself. That's all right. So once I get the paragraph.
In the judgment, it is at paragraph 68,
Thank you.
where the judge says, and to emphasize the nature of the fraud, the representations are particularly material because one of the conditions attached to the granting of the A-class license was that Key Bank lodge $3 million with a financial institution acceptable to the central bank, and that such representation was being used to meet this condition. But actually, with respect to the judge, he was absolutely wrong, because that was exactly what the basis upon which the appellants were inviting interest from the respondent, because they were saying it was that requirement for the cash capital which required the opportunity, which presented the opportunity to a potential investor. And, Your Honours,
Sophisticated investor, I think.
I'm sorry.
Sophisticated investor.
Yes, yes. Unfortunately, in our submission, the Court of Appeal can be seen to have fallen into the same error, because we see that in the judgment of Justice Awich at paragraph 55, which is on page 115 of the bundle. See, he is generally agreeing with the judge, and one of the things he agrees with in the middle of that paragraph is the statement, "I also agree that this was done in order to partially satisfy the central bank condition to have $3 million paid up share capital."
I don't mean to rush you, counsel, at all, but just asking, you will have sufficient time at the end to address the breach of contract point, will you?
I'm hoping so, yes.
Well, I'm hoping so too.
Well, yes, indeed. Well, obviously, the main focus of the courts at all stages has been on the representation point. Perhaps I can just wrap it up as far as I can by telling your honours that I have dealt with it in a little more detail in the speaking note. The fact, all of the representations, I've been concentrating on, well, the representations which we've been considering so far, but all of the alleged representations were predicated on the fact that they were said to give the appearance that the first defendant bank had already been incorporated, and the references to that are set out in my speaking note. We don't accept they were misleading, but in any event, what was alleged to be misleading about them is the fact that the bank had not yet been incorporated. And as you know, in due course, the bank did receive its Class A license, and it might be worth just mentioning that at no stage before the initiation of these proceedings in, I think, about 2013, 2014, was any complaint made about any of this. It was only brought to a head when the bank mistakenly forfeited the shares, which they accepted, and this is the concession. They accepted that they had done that, and it was only at that stage that misrepresentation, so to speak, reared its head. It doesn't appear to have occurred to Mr. Haugen at any prior moment, and indeed it was not mentioned, I think, in the letter before action that misrepresentation was what this case would be all about.
But not only that, I didn't see any complaint from Mr. Haugen about the bank. Well, the bank was established and it got the Class A license, but he also got, at least for one of his companies, a loan from the bank. Isn't that so?
Yes, that is so. Yes, that is so.
So,
and it is a nonsense. They now say that he never had these shares, which is what I'm going to come on to on the breach of contract point. But the whole point of the whole thing which went wrong, and the bank eventually accepted responsibility, was based on the fact that he did have shares. So bank would forfeit shares they didn't think he had. There's a wealth of evidence which appears to have been ignored by the courts below, which established that he was on every shareholder register, except for the one which the judge honed in on, which the bank accepted was mistaken and subsequently put right.
what I understand is from this letter which Mr. Haugen got from the bank at some point, that they said, well, you're liable for this debt of the company. The debt is around $300,000 US.
Yeah.
We got your account,
Yeah.
and we are going to liquidate your shares.
Yeah.
And therefore now what rests is a debt of $100,000.
Yeah.
So that means they gave a value to those shares.
Well, indeed.
So,
Indeed.
so if you do give a value to those shares, one supposes the shares were there, or at least existed.
Well, indeed, Your Honour, thank you. I had only very little left in relation to misrepresentations. I think my learned friend now concedes that the constant of a misrepresentation or a representation being substantially true is a legally valid proposal, although it was regarded by the judge at first instance as yet another instance of the way in which the appellants were acting fraudulently by pretending something was substantially true. But if I can turn to the breach of contract claim, it would be wrong, first of all, to make any adverse inference in the fraudulent misrepresentation claim to the breach of contract claim, which did not come into, or the facts upon which it based did not come into existence until some 8 or 9 years after the misrepresentations were alleged.
I think we have to be precise on which contract was breached.
Yes. Well, the concession only related to the events of 2011 and 2012. And I think we can see that is clearly summarized in the judge's order, which you find at page 177. And you'll see that there the concession is recorded towards the bottom of the page upon the defendants withdrawing their counterclaim and conceding that forfeiture of the claimant's shares, the crediting of the account of Pacific Paradise Limited, that's Mr. Haugen's company, with the value of the claimant's shares, and the withdrawal of $10,000 from the claimant's bank account were all unlawfully done and in breach of contract. Now, that was the concession. There was no concession as to the earlier contract for the purchase of shares, and indeed, as Your Honour has pointed out, the shares, certainly the appellants considered that the respondent was a shareholder, and as I've said in my speaking note on this point, there was a wealth of evidence that the shares did exist. The share certificate is at page 811. There was correspondence sent to the respondent as a shareholder. There was correspondence with the Central Bank of Belize, and that was in 20th of April 2004, page 836 to 837, which deals with the question of whether or not the respondent would be granted permission to become a subscriber to the shares, which is a condition of the Central Bank of Belize. There is a current shareholder roster at page 833. I think I needn't ask you to go to these particular...
If we take your point, Mr. Guthrie, that the respondent was a shareholder, you are conceding that in forfeiting those shares, there was a breach.
Yes, in 2011.
Correct.
But
so what I'd like for you to do is just to take us through the legal consequences of that breach by your clients.
Well, if your honours take my point and are with me on the question that he did receive the shares, then there was no breach of contract in 2003. So the question of whether or not he's entitled to the $200,000 odd simply doesn't arise.
But the question is, what does arise?
Sorry?
The question is, what does arise?
Well,
because you're asking us to allow the appeal.
Yes. And to set aside the orders.
To set aside the orders.
Yeah.
would that be it, or?
Well,
because there is still the, you know, the
Well, there is the breach of contract,
Yes.
but that had been made good because the $10,000 odd, which had been taken from his bank account,
Yeah.
had been returned to him.
No, sorry, but with respect, if there is a breach of contract,
Yeah.
surely that entitles the innocent party to certain remedies. Would one remedy be, for example, that the innocent party could repudiate the contract?
Well, he didn't purport to do that. That wasn't the basis upon which the claim was made. And that is not pleaded repudiation and acceptance of repudiation. So in our respectful submission, it's not open to him now to, so to speak, change the basis of his claim. It is true that he said to the judge that he wanted to have nothing to do with the appellants in the future, and he wanted his money back. But where is the legal basis upon which he would be entitled to do that? He's got his shares, which he purchased in 2003, 2004. He has had the money which was taken from his account returned to him. If there are any additional damages, then there should be an inquiry as to those damages. But it's certainly not right that he should simply be awarded the tortious measure of damages, which is appropriate only to the fraudulent misrepresentation claim. And on this matter, we say that the conclusion of the Court of Appeal of Belize was correct, and the judge could not make the award both on the basis of misrepresentation and breach of contract.
So in your view, allowing the appeal, that would be it?
Well, unless your honours were to think that it was necessary to have an inquiry into the damages sustained on the contract measure.
If any?
Yes, I'm sorry?
If any?
If any, indeed, if any, because it appears to have been thought by the judge that he could simply choose between a breach of contract claim and a misrepresentation claim, which would give the same result, but they wouldn't. Because if there was no breach of contract in the allocation of the shares, then he has the shares. So there would have to be, there would have to be an inquiry as to whether he has sustained any loss at all.
Mr. Guthrie, is it your position this morning that he remains, as of today, the holder of those shares?
Yes.
As a matter of law?
Yes.
So that the damages awarded are damages in a money sum that has been awarded to him, and as well, he has the value of the shares?
Well, the value would be deducted. I'm sorry, I'm not sure I'm following, my lord.
I think the Court of Appeal decided to rescission of the contract, so that would mean the bank gets the shares and he gets the money back.
He paid for the shares.
Yes,
Yes.
but the problem with that is on what basis did they decide that? They decided that on the basis that there would be a total failure of consideration.
Sure.
And I think we see that in a paragraph, I haven't got it in my head at the moment, but they did say, I think it would be rescission on the basis of a total failure of consideration because he hadn't got the shares. But if he had got the shares, that would not be the right measure.
If there had been I'm sorry.
Mr. Lumore has helpfully added a point for me to make, I think, in response to your invitation to consider the quantum of the loss on a breach of contract claim. He would be entitled to be compensated for any loss sustained during the period he was deprived of the shares and interest on any sum which was involved.
But you would not expect this court to deal with that, or?
Certainly not, no, my lord, if it would be necessary to remit it somewhere else. But I think it's perhaps also worth mentioning that not only did the claimant not proceed on that basis, he didn't put any information in which would have enabled a judge, if the judge had taken a different view to Mr. Justice Abel, to calculate what that loss would be.
Okay.
Yeah, you said that you did not think that the respondent would have been entitled to argue rescission. That is the impression I got listening to you. I'm looking at the amended statement of claim.
Yes.
Is there anything in there that assists us in that regard?
Where's that? Let me turn that up, my lady.
Because the rescission is on the basis, I believe, of the fraudulent misrep which had been alleged.
Yes.
But I'm looking at the breach of contract allegations in the pleading, and I'm not readily anyway.
Well, the breach of contract allegations, Your Honour, refer not to the contract.
Yes, I
but to
understand.
the Pacific matter.
Yeah.
It is not the case that the claimant said that, the way it's put in paragraph, I think paragraph 18, Your Honour, if you look at paragraph 18, by reason of the fraudulent misrepresentation, the claimant has suffered loss and damage, being the sum he paid for shares. In the alternative, he claims rescission of the agreement, but that, of course, is based on the fraudulent misrepresentation point. And in the alternative, the failure to allot the claimant 3,417 shares amounts to a breach of contract. But everything which occurs thereafter under the heading breach of contract relates to the claim which related to a golf course.
Yeah, and the 10,000 US.
And the 10,000 which...
Because when you come down to 41, 40 first to date, and he says the first event has failed to return the sum of the US 10.
Yes.
And then 41, he goes back to the fraudulent misrepresentation.
Yes, indeed.
Alleged.
Yes,
So
and indeed, the 10 had been repaid not at the date of the pleading, but at the date of the hearing.
Thank you.
Well, rather to my surprise, I'm able to conclude almost exactly within the hour.
Thank you very much.
There's just one small matter concerning costs, Mr. Guthrie, and I'd like your take on it as to, I'm not sure that I understood exactly what happened when this trial started, but it does appear that there was some hesitation on the part of the judge or someone that given the concessions that the trial should continue or should begin.
Well,
On this point, and I just wondered whether you thought that that is a matter which would be relevant to any order for costs that we might make, should we agree with you.
And I understand that Mr. Williams, your predecessor, insisted that this point should be tried.
yeah. Well, he certainly, there was, I think, an exchange between the bar and the bench, which went on for some time, trying to, shall I say, elucidate quite what was left and what the court was being called on to decide. And it is correct, yes, that Mr. Williams, who felt, I think, strongly that the misrepresentation issue was misconceived for very much the same reasons as I put before your honours today, felt that it should be laid to rest. But I would respectfully suggest that that ought not to be reflected in any way in costs, because he was, the judge received quite positive encouragement in, if I could put it, sort of running in the direction that he did from the respondent. And in our submission, it would not be right to make any other order of the costs in our favour. I also meant, and because of time, perhaps didn't deal with a short point, which is the question that Mr. Nagel was not present. Now, the Court of Appeal seemed to have thought that this was something which even the appellants were surprised about. And I have set out the references in my note, but if I can mention it, yes. Obviously, the fact that he was there would not alter the burden of proof on the claimant to prove the case, but it would not be right to make any adverse inference from his absence. The Court of Appeal said at page 101, at the top of that page, just above paragraph 9, Mr. Williams informed the trial judge that Mr. Nagel had not contacted him to provide explanation for his absence. Counsel had expected Mr. Nagel to attend the court and testify. That's actually a mistake, Your Honours, because if one looks at page 445 to 446, we see there is an exchange between the court and Mr. Williams about this. The court says, Mr. Nagel's not here, not at this moment. What do you mean? I'm saying he's not in court at this time. You expect him to walk through the door? No, my lord, I'd indicated to my friends. I don't want to get into that, but I've indicated to my friend the reason. I don't want to know, says the court. He's not here. There was a reason why he would cannot be here today, a legitimate reason. He holds certain diplomatic appointments and had to be on a mission. So there was no application for an adjournment, and the fact is that he wasn't there, and it's perhaps very unfortunate that he wasn't there, but it should not be held against him. But that's something I meant to mention earlier, and I have mentioned it now.
Thank you very much. No more questions. Thank you.
Thank you.
Mr. Courtney. We also got your speaking note.
As usual.
Your Honors, for what it's worth, and I don't suspect that it is worth much, I think what the Court of Appeal was referring to is to be found on page 515 of the record, where Mr. Williams at line 16 or 17 says to the court, talking about him not being present, he says, "That only came to my attention last Friday, and that is the position I find myself in, and that is why I said to the court, he has made a decision," simply saying that it was just before court that he found out that Mr. Nagel wasn't going to be there. But I don't think that that's of much moment in this appeal. Your Honors, I think it is critical to set a certain context for this appeal because things have shifted from the very beginning. There was dramatic change in withdrawing a counterclaim. Then there was even more seismic change on the day of trial when the concession was made, when Mr. Nagel, we found out, is not going to turn up. And I say emphatically, Mr. Williams insisted that the fraudulent misrep issue be tried. Mm-hmm. Your Honors, I think, and listening to the...
And you did not insist?
I tried very delicately to say to the court that we have an obligation to promote the overriding objective. I said, I have listened carefully to the exchange between Mr. Williams and yourself. Why are we proceeding? What exactly are we doing? Mr. Williams continued and insisted on the fraudulent misrep. So the judge, there's actually a statement by the judge that if he conceded and agreed to the 200, give the man back his money, we would have walked away. But I think Mr. Williams had an issue on the quantum. Mm-hmm. No, we could have tried that, which is a point we will come to based on the questions from the bench today. We could have dealt with that on that day, but the court sees from the transcript how things developed. Your Honors, it is quite right that there is a significant time gap between when Mr. Haugen became involved with Key Bank and when the issues, the differences between the parties arose. And I think it is important to start there. And I believe that that was in 2011. The court will be well aware that the problem started when they sought to take away his shares. It is incorrect to say that Mr. Haugen had actually been involved in the Grand Pacific Company other than as a director. I think the emails between them says that it was Mr. Nagel and Mr. Coons, I believe it is, who set up some companies to do this thing. He had been asked to go and design the course, and he was a director. Long point short is that because he was the director and the loan agreement, the approval of the loan was written to him, the bank decided that they were going to take his shares. In fact, they misrepresented that he had pledged his shares, etc. And just for what it's worth, Mr. Nagel was the one who also wrote an email when Mr. Haugen sought to try to address this in an amicable way and said, there is nothing to discuss. You pledge your shares. Under Belize law, we can do this. We're doing this, and that's the end of the matter. Pay your obligations, quote unquote. That is what triggered Mr. Haugen engaging attorneys. And the attorneys wrote the letter to the bank on the basis that it had no right to take the shares. Sometime after that, the inquiries was made at the company's registry, where there was no evidence of Mr. Haugen as a shareholder, which is what triggered the whole fraudulent misrep situation when Mr. Haugen says, listen, these people are, and he uses the word steal, these people are about to steal my money, because the court will recall that not only did they forfeit his shares, credit the amount, take the $10,000 from his account, they went further and blocked his other totally unrelated accounts. He says they're about to steal my money, let's sue. What am I attempting to establish? When the claim was filed, Mr. Haugen and his attorneys were under the impression that notwithstanding they had given him the share certificate, when they went to the registry, he was not there. They're stealing his money. They look at the letter and said, wait a minute. This letter is talking about a bank that is in existence. It is not in existence, that there was a board meeting, that et cetera, et cetera. The long and short of it is that at the time the claim was filed, Mr. Haugen's state of mind and instructions was that I'm not a shareholder, I have been defrauded, and they're stealing my money. Let's go after these people. The defense maintained the forfeiture. It was not until the day of trial, well, sorry, I should put it this way, in the witness statements, I believe in September 2015, that the defendants changed their position and said, oh, we have reversed that, we're going to give the man his shares. And in fact, more interestingly, they don't admit that they did anything wrong. They say it was a mistake. His name was to have been on the register. But if you look at the defense, they're insisting on their right to forfeiture, and it was not until trial that they conceded we did not have the right to forfeit the shares. Your Honors,
Did they not say that you can't find the name in the register because we forfeited it, so he's no longer,
right.
and then later on it became a mistake.
Mr. Roches, in fact, says that it was when I went to my attorney, and if you look, you will see his witness statement is dated the 7th of September 2015, and the amendment is made the following day, 2018. Clearly, when he went to his attorneys, they said, you can't do that, notwithstanding the fact that my learned friend, Mr. Williams, had signed the statement of defense on instructions. In any event, you have the picture as to why the case was pleaded the way it was pleaded, and it unfolded the way it unfolded. It is important, Your Honors, for me to say emphatically that the letter of the 14th of May 2003. The letter written by Nagel to Haugen. And the letter and documents of the 20th of May, 2003. Context is important. First of all, the quote-unquote prospectus is undated. But we do know that it predated the letter of the 14th of May. Mr. Haugen got the letter of the 14th of May, and we say that there are material representations in there which are false. My learned friends now say that, well, it is not false because when you look at the memorandum and the prospectus, whichever name you want to call it, it completely demolishes what he says he understood from the letter. And he takes you to the cross-examination of Mr. Haugen. Your Honors, with respect, and I will ask the court to look at the cross-examination. With respect, it is very important to see what Mr. Haugen is answering and the questions that are put to him. The question is put to Mr. Haugen repeatedly, what do you understand this sentence to mean? What do you understand this paragraph to mean? And he explains that. His state of mind in relation to what he was investing in, he makes very clear. And I think that that is very different. The point I want the court to understand is that the document of the 20th, the prospectus, did not, in my respectful submission, cure the falsity in the letter of the 14th of May. Your Honors, can I ask the court to take a look at the letter of the 14th of May? And I don't have to spend much time on it because the court, I believe, is familiar with it. My learned friend read the letter to you. But, Your Honors, Mr. Nagel, attorney at law, owner of the trust company of Mr. Haugen, writes this letter. And regardless of how one wants to varnish it, regardless of how one wants to attempt to attenuate the effect of what is here, he was inviting a person with whom he had a relationship of trust to make an investment on the basis of this letter. Your Honors, he misrepresents materially the true position.
Mr. Courtney, was the letter intended to say to him, make an investment or consider making an investment?
It was intended to say to him to consider making this investment and make it because.
Yeah, so if the letter was inviting him to consider making the investment, wouldn't the two later documents be relevant?
No, sorry, Your Honor. I am not saying that the 14th is not relevant.
Yes.
I'm not saying it's not relevant. I am saying that my learned friend is suggesting to this court that the letter of the 20th, the documents accompanying the letter of the 20th, destroy Mr. Nagel's assertions as to the effect of the 14th letter on him and what he was understanding the position to be. In other words, he says, when you get the letter of the 14th, read it along the two, and you will see, guess what? The document he sent on the 20th says proposed bank. So Mr. Haugen could be of no impression when he received the letter of the 14th that the bank was in existence, as Mr. Nagel had lied.
Is that what the argument is? Or is the argument that the invitation consisted of a preliminary invitation of the 14th, which was, if you are in any way interested, let me know, and I will send you the more formal package. An interest was indicated or expressed, and then the two documents come with the letter of the 20th, and isn't the argument that For fraudulent misrepresentation, we must see when we read all of that, but with particular interest on, let's call it the formal substantive documents. A, what statements of fact or representations were made? Were they substantially false, if we accept that's the law? And then 3, and important, no less importantly, was there any reliance placed on those? Do you accept that that is what?
Reading all the documents together and
That's a proper approach to be taken.
Yes, Your Honor,
You do.
I accept that. And what I'm saying, and I say that, and I say the documents must all be read together, and I go further, and I understand the notion that the formal documents are to be treated with some more importance. I put it no higher than that. But what I will say to the court is this. When one looks at the two documents, and perhaps we should go to the exotic key one first.
These are the documents of the 20th
The
now.
one with the 20th.
Yeah.
This page. Confidential and private memorandum. This memorandum is distributed as an informative tool to potential investors in Exotic Key Mortgage Corporation Limited. Currently converting to Caye Bank International Limited. This court will search in vain for any evidence that that is true. There simply is none. That there was any attempt, any notion of a conversion. I say that, Your Honors, because that was pleaded.
Yeah, but
He
it was pleaded to say that, you see, the bank did not exist at that point in time. So the complaint doesn't seem to go to the fact that there was no conversion.
Your Honor, it absolutely does. And I have in my speaking note, and there are a couple other points where I wish to point that out because my learned friend takes that view. Mr. Haugen is saying and has said from the Supreme Court and in the Court of Appeal and here that he complained that there was no conversion. And Your Honor, if I may give you those references.
I noticed that part of his cross-examination was not recorded. Is that correct?
That unfortunately,
Yes. While it was getting interesting, it certainly was not recorded.
yes.
Yeah.
Unfortunately, because this court will be very impressed with his cross-examination, as we were, and the judge was. Your Honors, can I just ask you to take a note at the record, page 779, paragraph 60A. And we have uploaded the pretrial memorandum and skeleton submissions which we use in the Supreme Court. I don't know the page number, but paragraph 26A. And finally, in the witness statement of Mr. Haugen at page 271, paragraph 22A. So those are places where Mr. Haugen expressly says that there was no conversion. I was led to believe that there was a conversion, and there was not.
But in this statement of case, what is the case? Because of course, witness statements are evidence, but what was the case pleaded? But sorry that, in the witness statement, it's page 271, para what? Sorry, just, can you give me that detail in the witness statement?
Paragraph 22A.
22A, okay, right. Yeah, sorry, yeah. I ask that because no doubt you would agree, I think, that if you are going to plead fraudulent misrepresentation, then the fraud ought to be clearly and specifically identified, particularized, pleaded and particularized.
Could I invite the court's attention to page 186, paragraph 11?
Is that your amended statement of claim?
Indeed, my lady.
Thank you.
The particulars, the first defendant would be converted from a mortgage company in business for over 5 years into the first defendant. The first defendant, Caye International Bank Limited, had put together a great team. He had been appointed chairman of the new bank's board, even though the said first defendant had not yet been incorporated. D, the first defendant's application for a Class A license was approved by the central bank, even though the first defendant had not as yet been incorporated and the central bank had approved a Class A license. And then E, which clearly was, we obviously can't rely on. So
In the chapeau to those particulars, what does it say?
the representation by the second defendant in May 2003 and the first defendant that the first defendant had obtained a Class A banking license was false and was made fraudulently in that the second defendant knew at all material times that at the time.
Right, and then the particulars are given.
Yes.
So those are particulars of the assertion that what was fraud, in the chapeau to the paragraph, what was fraudulent was that a Class A bank had not been incorporated at the time. And then what follows, I accept what follows is the mortgage company would be converted. But those are particulars of the plea. Is that not the way to read it? In other words, the primary assertion of fraudulent misrepresentation is, look, you represented that this was a incorporated Class A bank, but in fact that was not true. And here are the particulars. You said it would be converted, you said A, B, C, D, and it was not in existence at the time. How else is that to be read? Because the chapeau is what the assertion is, and then you were saying these are the details that support this primary assertion. Is that not how that is to be read?
Your Honor, but perhaps I'm not following the court in the issue that you're raising with me.
The fraudulent misrepresentation means there is a statement
Right.
of fact that is fraudulent, knowingly or recklessly so.
Indeed.
The chapeau sets out, to the paragraph, sets out what that statement of fact is. And I think it says that the statement of fact, the factual representation is that there was a bank that was incorporated, a Class A bank. Right?
Yes, Your Honor, that's what the paragraph says.
So that's this representation that you want to say is fraudulent. And you want to say, well, look, it's fraudulent because, and these are the details of what makes it fraudulent. Yeah?
Understood, Your Honor, but I would submit to this court.
As
First,
opposed to the conversion being, in other words, as opposed to saying the fraudulent representation was the conversion. It may seem subtle, but I'm not sure that it is so subtle.
well, Your Honor, first of all, our case is, and we would say that the whole amended statement of claim and the witness statement are to be read together. McPhillamy and Times, I suspect this court might be familiar with, says that the two are to be taken together in the new dispensation. In any event, Your Honor, when you look at paragraph 11, it is my respectful submission that a fair reading of the particulars, even though the court is saying that the fundamental premise of 11 is that the banking license was not issued, and then you're giving particulars, the particulars flesh out, and in this particular case, we argue conversion as one of the points.
Thank you.
Your Honors, on the fraudulent misrep claim, and I don't quite remember where I was or what I was going to establish when I was responding to that question, but I would like to summarize the fraudulent misrep situation, Your Honors, because I think the court will see that, well, I think I just remember, sorry. Could I take the court to the cross-examination that my learned friend took you to of Mr. Haugen, which is to be found on page 470. and then I will make a few more comments and move on from the fraudulent misrep. .470, where Mr. Williams says the prospectus. It's court there, 470. Down at lines. Thank you. This prospectus that you received, Mr. Haugen, that's the one you received, right? Yes, it is. You agree with me that this is a prospectus by Exotic Key Mortgage Corporation Limited, which is headed at the top. If you look at 118 and 119, Exotic Key Mortgage Corporation Limited. Yes, that is correct. And if you look at 118, it says Proposed Key Bank Limited. You see that? That's what it says on the front. Right. It says propose. Yes, it does. The word there, I suggest to you that it means that its Key Bank International is not in existence. It's proposed, right? It says propose. I suggest to you that mean to you that it's not in existence. It's proposed. Answer. That's probably what it means when this document was made up for Exotic Key Mortgage, Key Bank International. Yes. And that's important, Your Honors. This is a document that was given to you, you said. Yes. And I'm asking you, what is your understanding of the proposed, where it appears there in bracket, then Key Bank International? Exactly what it says, proposed. So that means it doesn't exist, right? It's proposed. That means that it may be in process of Exotic Key Corporation being converted into Key Bank, as they said. Mr. Nagel said in other statements. Tell us what you think it means. That Key Bank, it was stated to me that the mortgage company was going to be converted into Key Bank International, and maybe the conversion had not taken place. But that what the proposed would indicate to you that this conversion had not taken place? Possibly. Now, if you go to the next page, 119, the first 3 lines, it says, this memorandum is distributed as an informative tool to potential investors, so on and so forth. What do you understand, what that to be saying to you in the memorandum? It says, currently converting to Key Bank International, a issued Class A international bank. It says, a Belize issued or a Belize licensed Class A. Question, you accept that to mean that the bank was not in existence at the time you received this information? To me, it doesn't say that, but it says that the mortgage company is currently converting to Key Bank International. And so there's more, I won't read it. I just asked the court to go over to page 474, right at the bottom of the next page. If we could, line 13, question. Now, this memorandum, if you look at the top, was a confidential and private memorandum, but it is that Exotic Key Mortgage Corporation Limited, correct? Yes, that's correct. It was not one by Key Bank. It was not a Key Bank memorandum because, as you understand it, Key Bank was not in existence yet at that time. I found out later that it was not in existence at the time. That's correct. The point I'm making is that I asked this court, when you look at the cross-examination, my learned friend had referred to, there's a difference between Mr. Williams asking what a sentence means, and he's responding about proposed means proposed, future, etc., and what his understanding was at the time. Why do I say that? Because it is our case that the letter of the 14th was the one that he took as the primary document. Secondly, as the court has pointed out, even the Exotic Key Memorandum talks of converting. There is no conversion. Your Honors, I capture at paragraph 9 of my speaking note our position with respect to what happened to Mr. Haugen. That is to say that there was never a conversion from Exotic Key to Key Bank. Mr. Haugen never invested in a bank that had a 5-year successful track record. Your Honors, That is critical. It is critical. Whether you look at the letter or you look at the 20th documents, the representation to Mr. Haugen is that this is not a startup. We have 5 years of track record. We have made a tidy profit. This is going to be so profitable based on what we have already done. We are going to just convert from a successful mortgage company into the bank. We'll be up and running. That did not happen, and Mr. Haugen did not actually get his 3,000 shares in such an entity. A small point, Your Honors, but I think it is a part of the culture of fraud. When you look at the letter of the 14th, you will see Mr. Nagel making the point that it is
from the bank.